Want to sell your home for sale by owner, but worried about contracts and paperwork? Over the next 5 minutes, I'm going to walk you through the best ways to make sure that you're protecting yourself as the seller in the real estate transaction. This approach has saved my clients thousands of dollars in potential liability and lost profits. I'm also going to send you my link where you can get all your real estate questions answered by a local attorney for $30 a month with no contract commitment. Just drop me a comment below and I'll send that to you. For those of you who don't know me, my name is Wendy Atherton. I'm the owner and founder of Home Partners Marketing, where I work exclusively with for sale by owners to help them market and sell their homes without an agent. I've generated thousands of buyer leads online, and I'm an expert at online marketing. In my videos, you'll get at least one thing that you can implement that will help you sell your own home for top dollar. So over the next 5 minutes, I'm going to walk you through the best ways to make sure that you're protecting yourself as a seller and to maximize your results when you sell your home. So first off are disclosures. So in pretty much every state, there's going to be some type of disclosures that you as a seller are going to need to complete and provide to a buyer who is making an offer on your home. They vary completely by state, but generally speaking, it's going to ask you for information about the condition of your property. And, I suggest to people that if you know it, you tell it. And what you don't know, obviously you can't tell. But if you know things about your property, then you want to go ahead and acknowledge those things and tell potential buyers about those issues. So typically, disclosures don't take very long to complete. They're generally pretty simple. And if you drop the comment below, when I send you that link, real estate attorney in your state could, of course, tell you exactly which disclosures you need to be completing. And if you have any questions, or maybe you're a little concerned about a specific thing, they can actually give you some advice as well in terms of maybe how to answer that question. So property disclosures, number one, you want to go ahead and have those done. You want to be able to provide those disclosures to a buyer before the buyer makes an offer. So in certain states, buyers have the ability to get their money back or get out of an offer or get out of a contract if they don't have those disclosures when you accept their offer. So that's important. So that's number one. Next, let's talk about the actual offer itself. So in any state here around the United States, there are offer to purchase contracts that are used by real estate agents. If you are a for sale by owner and a buyer is represented by a real estate agent licensed in your state, then they're going to write you an offer using that form. And the real estate agent is obviously going to know, or should know, how to complete that offer based on the rules in your state. Now, obviously, most folks who are selling their home as a for sale by owner aren't experts in the specific contracts in your state. So again, this is where it can be really helpful once you get that offer to leverage that legal resource just to make sure that you're not missing anything significant in the contract that might harm you, right? Or your end goal. So, for example, you obviously want to make sure you understand any contingencies that a buyer has included as part of that offer. Do they have to sell their current house to be able to purchase your house? What happens if they don't? Or are there any other contingencies where it's very easy for the buyer to be able to just walk away, without much consequence? You potentially have now tied your home up on the market for some significant period of time. So it's a good idea when you speak to a real estate attorney to get a copy of the standard offer to purchase in your state, and maybe just take a read through it up front. That way you can review it, make sure if there's any provisions that aren't clear to you, you understand those before you're under the gun with an actual offer from a real buyer who is expecting an answer from you quickly. So that's just one piece of advice, okay? Next, contingencies and repairs. So you received an offer from a buyer, you negotiated the terms of that offer, and you signed the offer and you're under contract to sell your home. So now what? So generally, and every state's a little different, but buyers are going to go through the process of inspections and surveys and appraisals, and generally may come back to you with some type of a request, right? So what if the home doesn't appraise? What if they get an inspection and find some issue that they want either repaired or a credit? All of those things have to be negotiated during your period where you're under contract, right? So as this is happening, it's just important for you as the seller to, keep in mind what rights you have under the contract and what rights the buyer has under the contract. So in certain states, the buyer can exit the contract, but they forfeit, their deposit or their due diligence fee or whatever that looks like in that state. In certain other states, that's not the case at all. So understanding where you are in terms of that negotiation and, your willingness to, potentially have the deal fall out, right? So, is it something that you can make work with the buyer and come to terms, or are you better off just cutting that buyer loose if you can and pursuing another buyer to purchase your house? So again, that's where it's also important to just recognize if you're working with a buyer who has an agent, that agent should be pretty familiar with the rules of their buyer's lender. So for example, under certain loan products, you can only ask for so much in terms of a credit, for example, right? So, that buyer's agent should be advising that buyer. If there is no agent involved, if it's a buyer direct to you and you're representing yourself, then, there's just certain things that you just want to be mindful of. You want to make sure that you're keeping in touch with the title or closing attorney who's going to close your transaction. You want to make sure that your buyer's loan is progressing. So you want to be asking about that throughout the process. Are we what we call clear to close? Is this buyer's loan going to happen, right? So last thing you want to have is you get all the way to the end and all of a sudden you find out, surprise, their financing isn't going to happen, and it's been shaky for the past 2 or 3 weeks, but you had no idea because nobody told you. So those are just good things to continue to ask about. And then last, happily, it's closing day and you're going to, go to your title company or go to your attorney's office to sign on the dotted line to sell your house. And closing as a seller is a quick process. So, once you're under contract, the title company or attorney who holds escrow will be the one who gets your loan payoff for you. So, generally they're going to be asking you for information once you're under contract. They're going to get your payoff, and they're going to be the ones that they'll prepare the deed to transfer to the buyer, and then they will essentially close escrow. Everything gets paid out of escrow, and then you get your proceeds as well. So, things that you want to make sure you understand how they're going to work are keys on the day of closing. Want to make sure you understand that probably the buyer, most buyers would want to do a final walkthrough. So you want to make sure you know when that final walkthrough is, because you will want to be out by the time they do that final walkthrough. And when you go to closing, you want to obviously make sure that you have a valid form of ID, driver's license, passport, because it has to be the title company or attorney is going to be notarizing your documents, and they have to have a valid ID, cannot be expired. I've had that happen before. So you want to make sure you have that. And I also tell folks, be really, really careful there's so much fraud out there in terms of wire fraud. So typically the best thing to do is when you go to closing, bring your financial instructions with you, your wiring instructions if you want your proceeds to be wired, so that you can sit eyeball to eyeball. Make sure those are the correct instructions. You're handing those instructions to that individual, so that that when they close escrow, you're getting your funds how you should be getting them. So those are the big things. Again, drop me a comment below, and I will send you my link so that you can get all your real estate questions answered by a real estate attorney. It's $30 a month, and you can cancel it after the first month. It is money very well spent. Thanks a lot.